Well, today the Supreme Court has issued that no coercion action will be taken in this matter. Plus, they've also issued notices to the CAQM after the Delhi government approached the Supreme Court challenging the earlier order. On today, the Supreme Court, after hearing the arguments from the Delhi government, had ordered that no coercive action will be undertaken on the 10 and 15 years of vehicle of petrol and diesel. Now, this comes after now the notice has been issued to CAQM. Now, they'll file back their response to the Supreme Court, and after which we'll have a detailed hearing and then a final order after the after the CAQM files their response before the Supreme Court. And the Supreme Court did today issue the notice after the Delhi government approached them. When the last month the order came, it was rolled back, after which the Delhi government was considering about whether to move the Supreme Court and to when. And when they moved the Supreme Court, they actually challenged the earlier 2018 order. And today the Supreme Court has ordered that no coercive action will be undertaken while issuing the notice to the CAQM.
Well, Aditya, what about all those owners against whom action has already been initiated? What about them? Aditya, if you can hear me, the Supreme Court has now said that no coercive action will be taken against owners of 10-year-old diesel vehicles and 15-year-old petrol vehicles in Delhi. But what about those owners against whom action has already been initiated? Their vehicles have already been scrapped. What about them?
Well, this order is a prospective order, which is the order should not be applicable in a retrospective manner, which means if an action has already been taken, in that case, they might not get a relief with this order. But from today, with the order coming in, the order will be applied in prospective manner, but not retrospective manner, which means before today, if there is any action undertaken already, it will be in the face of the law as per the rules and the provisions which were already there and for the Supreme Court earlier judgments.
Well, Aditya, now what does this mean going ahead? What happens to all those who own 15-year-old petrol vehicles despite, their PUC checks? If their PUC checks, don't fall under the required standards, then what happens? Then coercive action should be taken, or should it not be taken?
Well, see, this is before the Supreme Court. The Supreme Court, it totally depends on what questions the Supreme Court consider while reviewing the earlier orders, on what ground the Supreme Court is set to review it. It totally depends on what question does the Supreme Court will consider while set aside the earlier order. So in this case, the first thing which most should be about the scientific, and the quantity should not be made a reason out of it. Now, this has been an application filed before the Supreme Court that just a number, just a quantity of year or a number of year being there for a car should not be the sole ground for the car to be towed or the car to be taken or seized. In this case, it's our CAQM to provide a paper justification and some documentation regarding what can be a better scientific reason, what can be a better scientific cause which can be undertaken for ensuring that if a car is being seized, it must actually be proven by some scientific reason and not just about a mere number of each of the cars before the car gets seized.